First time I lectured in these hallowed halls of Harvard back in the late 70s, a professor here is a friend of mine. We were knocking them out of the park back then in those days in personal injury litigation in Texas. And a professor asked me, he said, you know, you folks in Texas must have the most generous jurors in the world. They keep awarding all these big 7-figure verdicts. And I said, well, our folks are generous. They accurately reflect our populace. But they're also, I want you to know, there's some tough jurors in Texas too. And I told him about a voir dire examination I'd just seen where a hyperkinetic prosecutor, voir diring on the death penalty, asked this this elderly school teacher, nice lady, said, now you, ma'am, if you're chosen as a juror in this case, and if the state of Texas proves beyond a reasonable doubt the horrible, horrific, and horrendous conduct of this defendant, can you return a judgment of death by lethal injection? And she thought about that for a moment, and she said, you do that up in Huntsville, don't you? He said, yes, ma'am, we do. And she said, well, you know, I can't do it during the week, but I'd sure be glad to come up and do it on the weekends. So we have some, we got some pretty tough, I'm looking for her on punitive damages cases against these pharmaceutical companies is what I'm looking for. Okay, let me tell you a little, the absolute key to what's going on in the world of psychology. So, strangely enough, it comes from a man who received the Nobel Prize in economics for this book, Daniel Kahneman, Nobel Prize in economics. It is the most, this thing is, if my Bible were as dog-eared as this, I'd be probably a lot better shape eventually. But this is just the word on so much research, so much experimental psychology that completely has to do with persuasion. And so a lot of what I'm going to talk about has to do with things that I've been teaching for years, and Kahneman pulled it together better than anybody ever, and it's incredible to know. Let's talk about the predicate we're looking at today. When we walk into a courtroom today, a lot of jurors see this. What it does is it raises expectation. It raises expectation that they're going to hear more than just testimony from a witness stand. They expect to see things, especially when they see those little monitors in the jury box. And they expect us to inform them. Unfortunately, they also expect us to entertain them. David Kelly is one of our, is present in every courtroom. Because what he's done is created these impressions that when jurors come into the courtroom, they've seen it. They've seen everything David Kelly wrote, going back to LA Law, Ally McBeal, and Boston Legal. And boy, isn't trial fun? I mean, seriously, you get to listen to these 90-second closing arguments that turn murderers loose on society and bring in multi-million-dollar verdicts. So they come in with a high expectation that we're going to inform them and entertain them. And what do they get? What's the one word most frequently used to describe jury service by actual jurors? Hello, it's not rocket science. We bore them to absolute tears. So I want to try to tell you a little bit about cutting to the chase and some things that I've learned, especially from Kahneman. Kahneman just verified a lot of experience that I've had and a lot of things that I've heard from a lot of great trial lawyers over the years. Storytelling. Jerry Spence was the first guy I saw that really nailed it, as is so often true. Jerry said, it's all about storytelling. I think he published that in an article. It's all about storytelling, and that's the first time I've ever seen it. The lawyer with the best story wins. Now, what you learn from Kahneman is that we have what I've been calling for years conscious and unconscious mind appeals. He calls it System 1 and System 2, slow thinking and fast thinking. And when we're persuading, we have to think in terms of the two systems that we're persuading in the brain. The first system I call the conscious mind. The conscious mind is the part of the mind that actually calculates things. It's things that we have to ponder, have to think about. The unconscious mind is the part that automatically takes in everything. You know, when we deliver a persuasive message, the words we use, the verbal communication, constitute only 8% of the persuasive process. That's pretty amazing. That's not to say words are not important. Words are extremely important. We spend a lot of time with focus groups figuring out the exact words we need to be using. But it's only 8% of the delivery of your message. The vocal tone is 37% of the persuasive process. How do you sound? The use of, you just commented on silence. Silence is a very powerful tool. If you're standing in front of a jury and you've got a juror that's just not paying attention, or two or three, just stand there for a moment. And then they'll look up and say, what did I miss? They'll look up to see what's going on. It's a way to get people back, get their attention back. But vocal quality is extremely important. 37% of the persuasive process. What does that leave? 55% of the persuasive process is nonverbal communication. Because nonverbal communication is the part of the communication that is processed in the unconscious mind. It's what Kahneman calls fast thinking. We don't have to process it. And I'll talk to you a little bit about how we can get into the unconscious mind directly as part of our persuasive process. The trial story bias. Here's the important thing about trial stories. You don't have the only one in the courtroom. Each juror imposes their own narrative on the case. It's called the trial story bias. They impose their own, they create their own trial story. And here's the decision-making process. During primacy portion of the trial, each juror forms their own model of the case, their own trial story. Primacy is the acquisition of information, which we'll talk about in a minute. It's everything that happens up to voir dire examination. The voir dire and the opening statement, that's the primacy portion of the trial. And they're forming, at the end of the primacy portion of the trial, they have their own idea of what the case is about. That old thing about at the end of the opening statement, jurors have made up their mind on the decision in the case, that's absolutely wrong. That's not what the study said in the first place. And if it had, it would have been completely wrong. What is right is that each juror, by the end of your first witness, has formed in their own mind their idea of what the case is about. And it's their version of the trial story. So that's the important part of your trial story. Now, the decision-making process is orientation. Excuse me, I've got a little sore throat this morning. Orientation is what happens from the time, as Percy Foreman used to say, from the time they look through that little glass in the courtroom door when they're out there as a jury panel member and they're standing to see what's going on, from the time they walk in the courtroom, orientation begins. They start looking around to see what's happening. Now, Percy Foreman was my very dear friend and mentor and a hero, and unbelievable trial lawyer. But I watched Percy. I went over one time, he said, come over and just sit there and watch. And I watched him, and he said, look at me and look at the prosecutor when the jury panel comes in. So the sheriff starts bringing the panel in, and Percy's back here talking to the court clerk. How are you? Good to see you. Then he walks over and he shakes hands with the court reporter. This is what the jury sees, the panel sees as they're walking in. He walks over to the sheriff. Sheriff's bringing the people in. He walks over here. He stands here, and his message is, his nonverbal communication is, good morning. Welcome to my courtroom. This is my clerk. This is my court reporter. My judge will be here in just a minute. And the 12 of you who are privileged will get to be my jurors. He owned the courtroom nonverbally. Now, I looked over at the prosecutor, and the prosecutor was literally like this. And what was his nonverbal? Oh my God, they're here already? You know? So, first impression. You only get one chance to make a first impression, and that's the important one. All right, so orientation. They have conflict. They see something different than what they expected when they got there. So conflict comes up, and then they start out of conflict. You hear the prosecutor side, you hear the defense side. Out of the conflict emerges. They start emerging their own version of what's going on. And then here's the important part. They start, once they get that trial story in their mind, they start looking for evidence that will reinforce it. So the role of the trial story is a filter for the evidence. They look at things in terms of their view of the case. Now, they filter it through their view of the case. Now, the gaps, when you leave gaps in the evidence, gaps are filled by what? By their own biases. But so keep that in mind. Bias comes into play very heavily in the absence of evidence. They got to do something. They got to make a decision. So just be sure that you're covering everything you need to cover. Be sure you're not leaving gaps in the evidence. How do you do that? You test your case before focus groups, and you listen to them deliberate, and you learn from them where your gaps are in your evidence. Now, their trial stories are based upon their value beliefs and on their own personal life experiences. So you have to pay very close attention to the life experiences. So the more data you can get on the life experiences of your jurors, the better off you are, the better chance you give yourself. The juror's trial story, here's where they use it. They use it to perceive information in the first place. They filter. Then they store. They store it in their memory, in the short-term memory, and then most importantly, when they get in the jury room and they have to retrieve information, they retrieve in terms of their own trial story. They search their own mind for their own trial story, and that makes it extremely important. So you need to argue, direct, cross, close, and persuade in terms of your trial story. Now, once each juror forms the trial story, they'll seek evidence that supports it. They form beliefs during primacy, and so what you should try to do, you need to try to tap into the model. First, you want them to accept your trial story as their own, but you want to tap into the model of the leaders of the jury. We always watch jurors during the breaks. I don't do it, but I have people that are watching the jurors during the breaks, and you watch how they congregate. You see these same little groups of 3 or 4 hanging out together every time they have a break or when they go to lunch. And in that group of 3 or 4, there's that one person that's doing 90% of the talking. It's not going to be any different in the jury room. So you try to identify who your jury leaders are, obviously. And we can all tell horror stories about how wrong we've been there, but even more horror stories about, then you try to identify among those leaders who's on your side, who's going with you. And that's where the horror stories really come in.